Good morning.
Good morning. How are you?
I'm very, very well.
Good
Ken, good to see you, sir.
Yes. How have you been?
Very, very well. As you know, the weather is beautiful this morning.
Yes, it is. Beautiful day.
Excellent. I just thought, I know by now, I'm an author of the book, Pocket Without Holes, 7 Pillars to Support Your Financial Habits and Decision. And it chronicles my journey about finance.
Yes.
Now, what I'm doing now is I'm interviewing people with expertise in their fields, just so that we can I will let people know exactly what there is that you do that makes you successful in your field, as an inspiration for those who are looking to become entrepreneurs in their field, as well as to the next generation. So I'm going to let you introduce yourself briefly, and then we can take it from there.
Thank you, Douglas, and congratulations on your new book. I haven't finished reading it. I promise I'll do so.
Brilliant.
The bit I've read is quite informative and educative, and certainly I'll recommend it to anybody that wants to succeed, because there is nothing better than experience, and it mustn't be your personal experience. You can learn from others' experience. So, like you said, your experience from starting as an immigrant to where you are now, it's a roadmap to a lot of people. And like I said, I'll highly recommend it. Yes, I'll say that my name is Kennedy Obierozie. I'm a lawyer, a solicitor, and the senior partner of Lexpert Solicitors LLP. Lexpert is located at Commercial Street in Aldgate.
In the heart of London, the city of London.
Well, on Commercial Street. Well, you can say that, not too far from Liverpool Street and in the center of London. Okay. Yes, we are a civil set. By that I mean that we are concerned solely with civil law. We do immigration, all aspects of immigration, from family to business, from visit visas to work visas. And we advise individuals as well as organizations and even charities that are looking at bringing immigrants or working with immigrants. We also do litigation, civil litigation, property litigation. In fact, that forms the bulk of our practice.
Litigation.
And that is an area we want to be known for. Okay, we help people defend claims against themselves, and we help bring claims on behalf of our clients. We also do family law, and that entails all aspects of family, ranging from children to divorce, financial settlement, adoption, child arrangement order, any aspect that helps the family to stay together. And if for whatever reason, the two individuals that are involved in the marriage decide to part ways, we help them to achieve that as amicably as possible and with fairness, so that whatever is due to our client as part of divorce settlement is achieved. So we deal with family matters also. Another aspect of our practice is property. We deal with property litigations, any form of disputes arising from ownership of property, from leases, from occupation of properties, either as a tenant or as a leaser, or as anybody that has to deal with your rights relating to your property rights, actually. Also, we deal with leases, we deal with tenancies for and on behalf of landlords, also for and on behalf of tenants. So we deal with possession claims, bringing it on behalf of landlords or agents, and defending it on behalf of tenants. We'll deal with disrepair If you're in a property and for whatever reasons your landlord is not keeping up to his or her contractual obligations to keep the tenant, the property in tenantable condition, we will help you enforce that. We also deal with all aspects of neighborly disputes that might arise.
What is that one? That is a big word for me.
Okay, well, you see, like you have a property and for some reason you get into dispute with your neighbors. It could be as a result of antisocial behavior claims.
Yeah.
It could be boundary claims. It could be anything that has to do with disagreement.
Yeah.
Okay, so we assist either to bring it or to defend it.
I see.
Also, we deal with aspects of wills and probate.
Mm-hmm.
And this is one area that especially our people are not very clear about. Okay.
Okay.
There is.
It makes sense. Yeah, go on.
There is a lot of ramifications to this because wills, obviously, the only thing that is certain about life is death.
Okay.
And some.
You know what? Before we move into the nitty-gritty of this, it's a good introduction.
Yes.
So it appears as if your company name is what? Lexpert.
Lexpert. And may I trouble you with what it means?
Yes.
Lex obviously means law.
Yeah.
That's the Latin word for law.
Yeah.
And you all know what expert means. So if you join both together, it simply means law expert.
Makes sense.
So and that's what we strive to be.
Okay. It appears as if you do a lot. You have the immigration side, you've got the litigation side. My particular interest really will be in the property litigation, the wills, the probates, you know, those particular areas, because a lot of my followers, a lot of people I deal with are investors into real estate and businesses. And so leases and all of those things will come to the fore. So I'm very particularly interested in what you're doing. As far as your outfit is concerned, you know, can you give us a bit of assurance that, I mean, about how long you've been together, or you've been set up as a business, and you know, what are your successes, if you like?
Well, personally,
as a firm.
Yes, personally, I've been a lawyer since 2001.
Yeah.
And believe it or not, that's all I've done since then. Mm-hmm. Yes, I've worked in a lot of law firms, from being a solicitor at that level to being a partner in different law firms. Mm-hmm. But Lexpert Solicitors was established about 4 years ago. Mm-hmm. And since then, we have maintained consistently good track record in delivering on our clients' expectations. When I say expectations, what we try to do from the onset is to manage our clients' expectations. People come with varied problems. Yeah. And there is no one-fit-all solution. We try to be very frank and sincere about what is achievable. And from the onset, we make it clear that, listen, this is the problem, these are the solutions, these are the likely outcomes. Mm-hmm. So there are no
gray areas.
Yeah, there are no gray areas.
And there are no surprises.
And there are no surprises. And what we try to do again, because from experience, one of the critical issues clients have with engaging solicitors is cost. And understandably so, because people don't keep monies aside for solicitors in case anything happens. It's usually things that come up and then you have to look for money. So money is definitely an issue when instructing solicitors. So what we try to do with our clients is to be clear about possible cost. And at each time, we make sure that before we undertake any aspect of your work, we are very clear about the cost implications and you are carried along. We don't give you any surprises. We don't appreciate it because at the end of the day, we one time or the other want you to be able to come back. Okay. And from experience, one of the most difficult aspects of a lawyer-client relationship is, this your fees.
Right.
No matter how well you deliver or
fees, and I think trust as well.
Yeah, trust. And again, sometimes the trust is usually broken down based on non-clarity of fees. People come to you because they want a result, and they want to achieve this result on a budget. Because sometimes if these results are achieved at a cost that is not proportionate, it loses the essence. So
you've hit the nail right on the head there.
Yes.
About in finance, we have KYC, know your client.
Yes, yes.
And I'm sure in legal, your legal industry is the same thing.
Definitely.
You mentioned something about client expectation. You say that at Lexpert, from day one, you like to get the client on board about expectation, because we come with our own expectations, whether it's litigation, whether it's property litigation, whether it's civil matter or anything. And as you say, we come with a financial plan and money cost that we have in our head to be what we think you should be charging us. What happens when clients come in and first of all, the expectation is not met in terms of the costing? What arrangements do you do to make sure that the client stays with you and goes on with the project?
Okay, let me go back to something you said, and in terms of client expectation, specifically as it relates to cost. We don't just discuss that with you, because if we do and everybody walks away, then it's left to your recollection and my recollection, and sometimes 2-3 years down the line, it might not be accurate. What we do is to issue you, before we start work, what is called a client care letter. In that client care letter, we document clearly what your instructions are to us, what our advice is, the fee estimate, and the likely aspects of your case. So this is the working document. You can say it's a contract, but in a loose form, that you will go back and read, and then you are going to, we really request that you do sign it as a confirmation that you understand the basis on which we intend to work for you. So that is our own way of keeping things very neat and simple. So moving on to what you talked about in terms of clients not having the level of money that is required to push their case through. It happens all the time. Like I said, nobody has a trust fund for, solicitor's case. Things come up and you have to make adjustments. We have flexible funding arrangements, okay? Usually, and broadly speaking, solicitors charge in 2 ways. One is obviously the hourly rate, where you are charged for the amount of time spent doing your work. The second aspect is, or the second method, is when you have what is called a fixed fee arrangement, where we are saying for us to do from A to Z, which is a defined level of work or milestone, this is how much you are going to charge. Both, are clear in the sense that you know the basis of our charges. For the hourly rate, in terms of hourly rates, they are regulated in the sense that the Law Society or the Solicitors Regulatory Authority has defined rates that solicitors charge based on their level of experience and where they are located. These are the two factors: the level of experience, how many years you have been qualified for, and your level of, and where you are located. Those that are in London, of course, have enhanced charging rate. Then if you have experience ranging from 8 years plus, litigation experience, you are graded as A. And, obviously I'm grade A, but in Lexpert, we have grades from A to D, which means
so you've got a number of partners, people working in the firm.
Yes, you have someone that is at your fee level that can deliver on your work. That's even said, even with a grade D, who is a paralegal dealing with your work, I still maintain supervisory role over what is being, sent out, or what is being advised, or what the work we are presenting on your behalf. So that is in terms of fee levels. There are other fee arrangements we do make depending on what.
For example, you have what they call no win, no fee basis. Can you clarify on that one?
No win, no fee. The Law Society is not very keen on using that word. They call it now conditional fee arrangement, CFA. What it means is
conditional fee arrangement.
Conditional fee arrangement. So what it means is
conditional fee arrangement.
Yes. There are different aspects. I wouldn't bore you with the different aspects of it. But in general, what it means is that your fee is based on the outcome, the condition of the success.
It's based on results.
It's based on result. So if you are, and it's usually best for cases that you are expecting something in return. Okay, let's say you are expecting a payout or a compensation or whatever means that you are going to be getting money back as a result of the litigation, or getting property, or getting advantage. So we will be saying, well, we are going to work with you. We are going to assist you with your legal, give you the legal support until the outcome comes. Then you pay us. Most times it could be, and we do offer that, you don't have to pay anything in the event that you don't get the desired outcome. So it's a case of, you have a good case. Okay, we believe in your case. We are going to invest our time and resources to help you achieve it. And if at the end of the day, which we believe will be the case, you get what you want, then we take our fees. So our fees only becomes payable when you achieve your result. There is another one called there's another one which is called the DBA, damage-based agreement. That is based on what you recover, a proportion of it. So let's say you recovered property worth £10,000, or you recovered a payout worth X amount. We take a proportion of it, 10%, 15%.
And is this proportion, is this percentage set out from the onset in the client care letter?
Definitely. These proportions and even the CFA are regulated. That is the level you are not allowed to go beyond.
Okay.
You understand? So, whatever you do, you cannot go beyond a certain level, 25%.
Right.
Okay. Every other thing you're entitled to is within that level. Okay. So that's for all that. Again, we do as a firm offer pro bono services. Pro bono services are where you obviously don't have the means to pay. But we believe that justice should be done by pursuing your case. So we deploy our resources to assist you in recovering whatever you are pursuing. So it's absolutely at no cost to you. And in terms of our outlook as a firm, we have 5% assignment of our whole caseload for pro bono services. In fact, we currently liaise with the Citizens Advice Bureau, where they send people to us, clients to us for pro bono services. These are people that have approached the Citizens Advice Bureau for advice, but because of the cutbacks in resources available to them, they are not able to deal with it. And the essence of going to Citizens Advice Bureau in the first instance is that you want free services. So these people don't have the means to pay. So we tell them, and we have a working arrangement with them, the CBA in Brent and other CBAs around us, where they signpost these people to us. So what these people do is to call us up and say, well, we have been signposted by CBA. We have these issues. How can you assist? And we treat their cases absolutely free and advise them what to do. So this is obviously there, but of course it's subject to qualification. We have to be convinced that it's justice in the case, because again, law is not just a profession, it's a vocation. Part of what we try to do is to achieve justice for those that cannot pay and those that can pay. So
that sounds interesting.
Yes.
That is absolutely interesting. Once again, I'm going to veer your attention to property. A lot of the people I deal with obviously are homeowners and property investors. And litigation is no stranger to real estate. In terms of the services you offer, I have had a lot of clients come through where the parties have been married before. They've parted ways, sometimes divorced, not divorced, properties in joint names, woman or most of the time, as in my experience, one party, particularly about 80% of the time, is the lady who has the property, and she's been paying the mortgage, and the man is maybe moved on or something else. And the woman or the party who has the mortgage responsibility wants to be able to either sell the property or take the name of the spouse, divorced or not divorced, from the property. And it's becoming increasingly difficult. In such circumstances, what are the remedies? What are the areas is that what you guys do?
Yes, that is one of our areas of practice. And like you said, these scenarios are becoming more commonplace. When marriages break down, people move on. Some move on without looking back. Some move on without, tidying up their financial commitments. And sometimes the other spouse is left with ongoing responsibilities regarding properties, debts, even child care. So one of the things we do in the family section is to bring appropriate applications, either to get the fleeing, and I use this advisedly, fleeing spouse to make contributions towards this. There is the platform of divorce and financial settlements, where the court will adjudicate on the financial assets of the marriage and liabilities also, and then aim at sharing this proportionately. In the scenario you have talked about, it could be that after going through that process, the court might find that the entire beneficial interest of the property should be transferred, beneficial and legal interest should be transferred to the spouse that we represent or who is actually bringing the application. That we can help to achieve. However, nothing can be done without the order of the court, because property is such a regulated
industry
that you cannot just by wishing to do so take somebody's off name the register. Okay, there has to be a process. It's either by agreement or by court order. Most times before people come to us, it means that agreement is no longer feasible. So what is open to us, or the only option that we can deal with and help them achieve, is to go to court. Court has powers based on the merit of the case to give reliefs that you seek. Reliefs might range from making a declaration that this property should be sold, and then the court will then sign, execute the documents on behalf of the other spouse that is not cooperating. Because sometimes people feel that if they don't cooperate, they will frustrate the sale. It's not all the time true. If it is seen to be your intention, an appropriate application can be made to court to make the requisite orders that whoever is the other joint tenant should proceed with the sales without you being involved. So there are a lot of remedies open to such individuals, but again, these remedies depend on the particular scenario, particular case, or particulars of the case in hand. But what I want you to take away is that the court is such that those kinds of scenarios can be dealt with the aim of achieving justice for the people involved.
Mm-hmm. Okay, back still on property.
Yes.
I'll move us on to tenancy issues. As you know, I've been a real estate investor for a long time, and I've been a landlord, and I've had my fair share of the headaches in court. In fact, at some point, I represent myself just because I couldn't afford the court fees and all that. But in terms of tenancy issues, where does your firm stand? You can represent the landlords like myself, or you can also represent the tenant when they come to you. What kind of areas do you tend to get your cases from? And what kind of solutions do you provide for both landlords and tenants at the same time? And what are the law issues, the legal issues, the latest legal issues that affect tenants and landlords at the same time that you deal with?
All right. Due to this COVID situation, there has been a lot of changes in terms of abilities of landlords to be able to ask tenants to leave. Obviously, we are in a global pandemic. These are unusual times. So government, as representative of the people with the mandate to ensure that people's lives and properties are protected, have in their wisdom come up with legislations to guide the relationship between tenants and landlords, to the effect that from March up until 24th of this month, there was a total ban.
August. We're speaking in August.
Yes, August. There was a total ban on eviction. Okay, you can give a notice, but instead of the
lockdown and everything.
Yes, instead of the normal 2 months notice, if it's a Section 21, and sometimes 2 weeks notice if it's a Section 8, they made it mandatory that notices should be given for a duration of 3 months. However, due to the pressures that housing charities, labor, and other interest groups have been mounting on government, they had to make a U-turn on the 24th of August deadline. So they extended that again, and the position still is that tenants cannot be evicted. Yes.
So if you have an unpaying tenant, you are between a rock and a hard place.
It is. And I have a lot of landlords that are actually frustrated because for some reason, and you know human nature, some tenants have taken it to be a payment holiday.
You know the law more than you and I, believe it or not.
That is not the intention, and that is not the law. Your contractual obligations to pay rent still remains. What the government has intervened in is just the ability of landlords to evict.
If the tenant is not paying the rent,
yes.
For example, tenant is not paying rent for 3 months, 4 months,
yes,
and you still cannot evict because there is such legislation in place. Yet the landlord must pay the mortgage. That is not fair.
I understand that, but again, the government is trying to do what is called a balancing act. They have to balance between the rights of the landlord and the rights of the tenant. And in their wisdom, they felt that the tenant, being the smaller man, needs more protection. Obviously, there are arguments for the landlord's side of the defense, whereby one of the things you've said now, if tenants, for whatever reason, is not paying rent, the landlord is still obliged to service his mortgage, but he cannot tell the tenant to leave. So it's a difficult.
Where does the landlord get the money to service the mortgage?
Well, that's the problem. That's the practical problem that this has presented to us. Okay, but the only I'll say this, and hopefully it will come out the best way for landlords, if that is a comfort. The only comfort is that at the end of the day, the tenant is still liable for these arrears of rent. I don't know whether that makes sense, but that is the
position. It makes sense, but if the tenant is a man of...
It's not an immediate it's not an immediate relief.
Relief, yeah.
Yes, and like you said, from experience, sometimes these tenants run up arrears of £10,000, £20,000, which they are not good for. You understand? Even if you get the judgment against them, you are unlikely going to recover that money.
Mm-hmm.
So the best advice, and this is what I tell my client, is prevention is better than cure. Prevention from getting in a tenant, because that's the first step. Vet wisely. If in doubt, take guarantors.
Mm-hmm.
Because once you get in anybody into your property, and that property is a residential property, the law provides protection for that person.
I know that too well.
No matter how he managed to get in. Because sometimes people will say, I didn't give him a tenancy agreement. No, it doesn't matter. He's a tenant. In fact, in law, there is no obligation for contracts to be in writing.
It's implied, can be implied.
It's implied, it's by conduct. The mere fact that he's there, presents a rebuttable assumption that he is a tenant. And once he's a tenant, he gets all the protection that the Landlord and Tenancy Act provides, i.e. that he cannot be evicted without a court order.
Yeah.
And in good times, the average time from notices, which will take about 2 months, to having bailiffs evict a tenant is from 4 to 6 months.
Wow.
So it is a costly mistake, which is better prevented. So in terms of the law and how we can assist, I think that's your question. Currently, we do work with landlords. Okay, we do work with agents that act on behalf of landlords. And we do work with tenants. We have 1 or 2 housing associations we work with. So our experience in this aspect of practice is quite diverse. So we, depending on who we are working for, we have an insight into how the other side reasons.
Yeah.
We have an insight into how they are going to approach matters. And we advise our clients accordingly. Okay, so in terms of tenancy, the best advice for landlord is be proactive. Serve notices once you notice that the relationship is not going well.
Or at best engage the services of lawyers like yourself from the onset. Is that advisable?
It is advisable because it costs more to remedy a bad situation.
Start on your own self and mess it up and then want to get a lawyer to do it.
I'll give you a scenario, and that will buttress my point. If you're a landlord and you get in a tenant, and the tenant is owing you 6 months of rent. Okay, let's be realistic, 3 months of rent, and then you suddenly woke up, and then you serve a defective notice. You give the tenant 2 months. You end up getting to court before a judge in the next 2 months. That means you've spent 8 months on this journey. And on the day of the hearing, your claim is dismissed for defective notice, for one problem or the other. You have lost 8 months of rent. But the downside and the most agonizing aspect is that you will still be exposed to the cost of the tenant defending himself. I've had clients that are landlords that have gone through this same scenario, and they have a cost order of £3,000, £4,000 that they have to pay the tenant for his cost of legal defense.
In addition to the mortgage.
In addition to all they've lost. And that is not where the losses cap. Because remember that the relationship is broken down. So apart from the 8 months you've lost, apart from the £3,000 you've paid, you will now still have to start everything afresh. So you have additional 4 months to go with this tenant or more. So the cost of making that mistake is very high.
I see. Wow.
So when sometimes you say, well, you know what, I don't have X amount to pay solicitors to do it. Well, what you are bargaining for is paying more.
Yeah.
That's the option.
Well, less. You think you're paying less, but you're actually paying more. Less is more.
You're actually paying more. And you are not factoring in the stress. Because come on, these are very stressful, positions.
As a landlord, you can only, you preach into the converter, because
yes.
I have had nights I've had to sweat blood, literally, yes. Because you look at the number of properties that you have litigation with in the courts.
Yes.
Tenants are not paying, council tax, and yes. A lot of these
issues. The obligations remain. The monies are not coming in. Yes.
I've been there, done it.
And the annoying thing is, sometimes after these 8 months, 12 months, the tenant just disappears.
And you can't do anything about it.
And you can't do nothing.
And they decimated the property that it will cost you more to bring it back to habitable state again. So that is another tier of cost.
That's another tier of cost. That's another tier of cost. So the cost of getting it wrong can only be imagined.
Yeah.
You don't want to do that. You don't want to get it wrong.
Yeah.
The nature of possession applications, there are a lot of things. Okay, it could be that the preliminary documents, the prescribed documents were not served the way they're supposed to be served. It could be that in your application, the proper notice were not served. It could be that the proper notice period were not observed. Sometimes it could be that, the tenant was not even made aware. So you don't know until you get to that court 6 months down the line.
Yeah. Okay, let me pull plugs up on this bit, because we can talk about this all day long, because for me, I've experienced personal pain in managing this. And, if I had to advise in fact, this particular segment goes well for people who are looking to buy to rent and those who already have properties that they're renting out. I hope they'll take notice of it. Of course, I'm on the side of the tenants as well, even though most of the time I've sworn most of my life fighting tenants. So that is the point there. What about businesses who want to start up? You see, a lot of the businesses I coach, sometimes they tend to not want to engage the services of legal experts like yourself from the onset until issues crop up. And again, costs accumulate before they come to see. So what is your advice for businesses that are setting up, or even existing businesses who don't have legal advice or legal experts like yourself they work with? What is your advice to people in business?
My advice to them is that they are taking a big risk. All it takes to shut you down is one bad litigation. No matter how big you are, no matter how prosperous, no matter how viable your business is, all it takes is one nasty litigation from whatever source. It could be employees, it could be business competitors, it could be suppliers, it could even be your landlord. Okay, so bearing that in mind, again, prevention is better than cure. Get in a lawyer. Before you get into that contract, get a lawyer to look at it. Take advice. Don't go into it on the basis of what you think.
Yeah.
Sometimes people come to me and they say, well, this is what we discussed. I assume that that's what's in the paper. No, it's not. Or when I read it, this is what I understand it to mean. These are not defenses. It's either what it means legally or it is not.
Yeah.
Another thing that I find very common with businessmen, of course, for someone to set up a business, for someone to run a successful business, he must be intelligent. He must be smart.
Yeah.
But again, law is not common sense.
Mm-hmm.
People think to equate the ability to run a business, the ability to crunch figures, the ability to do whatever they do with legal knowledge. It is not the same. There is a reason why people spend 5 years, 6 years reading law.
Mm-hmm.
If it is common sense, we all just leave from high school and establish law firms.
Yeah.
So, especially in contracts, there are definite meanings to every word, every phrase, every sentence.
I get it.
That has to reflect your intentions. Because if it doesn't, you pay dearly for that.
Fantastic. I'm going to go on to two issues. One is the last bit, which is to do with consumer rights.
Yes.
I know we've talked about a lot of issues, including litigation and property rights and Tenancy Act and all that. A lot of the people I deal with also have, consumer issues. They've high purchased some item or mobile phone, little bits of expenditures, which perhaps they've missed out, being on default, been registered CCJ against, and all of these cost a lot in terms of effect it has on their ability to obtain credit, particularly mortgages.
Mm-hmm.
What are the services your firm performs that would help people who have issues about default, CCJs registered against their credit, and also other litigation with services they've bought or not bought, or paid or not paid? What do you do to bring some comfort to them in this regard?
Okay, basically, these are contractual issues. When you go into a contract, there are obligations, there are responsibilities. Sometimes people don't live up to these responsibilities, and the CCJs or the markers are consequences of that. But again, these things sometimes are done without people knowing. There are instances of people changing addresses, and then suddenly they want to buy a mortgage or they want to get a mortgage, and they find out that there's a CCJ again. In such instances, we could assist by making an application to set aside these judgments. There are conditions that has to be met, and once we advise you and we are satisfied that these conditions are met, we will take up your case. Okay. I've heard it, I'm not sure where they say that credit is king. To live in this economy, you need access to credit.
Yeah.
Be it mortgage, be it business loans, be it all manners of facilities. Yeah. So anything that dents your credit ability, it's a problem. Yeah. I have recently dealt with a gentleman that has a reasonable portfolio, and he wants to refinance his property. And suddenly there is a CFAS mark on him, which is not aware, and he couldn't. Yeah. We took it up with CFAS, and CFAS directed us to Lloyd's, where this marker originated. And a few weeks ago, after robust representations to Lloyd and threats of going to the ombudsman, that has been taken away from his file. So our client is now left with a clean credit.
That's a good result.
So CFAS is one big problem, because people think that once you have a CFAS mark, you don't have a recourse. We have instances of people that have their bank accounts closed for no reason. You get a transfer from your friend who, for whatever reason, it's not very straightforward. And the bank tells you, well, we are closing your bank account without reason. Even though they'll say, well, it's not an indictment on you, but again, it affects how other institutions look at you. Yeah. We've challenged this successfully with the institutions. We've escalated matters to the ombudsman, and in most cases, we've been successful in obtaining those decisions. So clearly, it is not the end of the story when you have a CCJ. or when you have any mark on your credit, speak to us. We listen to you. We advise you. We'll tell you what can be achieved, if something can be achieved, and we provide you a roadmap to achieving that.
That's interesting because, you know, a lot of people, I tell people when I do my webinars and presentations, I said, your credit report is like your passport traveling.
Yes.
If you're traveling and your passport is dented, there's issues with your passport, you cannot go through the airport. No. It's the same way with your credit. I tell people, guard your credit here in this country and in the Western world as if your life depends on it. Yes. And truly, your life actually depends on it, because
your financial life depends on
anything. Your financial life, of course, not your health life. Your financial life depends on it. And you know, they say happiness is being able to do the things that you want to do. Ken, I can't thank you enough. We will do a second series on this one here. But if people want to reach you, you know, what do we do? Shall we get them to come to you, or what is the take?
Well, you know, I'll smile while I say this. You know, one of the things that COVID has taught us is that you can speak to anyone, you can engage anyone from the comforts of your bedroom.
Yeah.
Okay. You know, you can call us up, you can send an email.
Yeah.
And then we can, you know, have a Zoom conference. We
Excellent.
can, you know, we try as much as possible, because there are still some traditional clients that want to see
your face,
look
handsome face,
and instruct you. We have a physical office which is up and running and is well resourced.
Yes, I've been there several times myself. So
yeah, we are happy to welcome you if that's your choice in our office. Of course, you know, observing the social distancing rules. Yeah. And if you are not that inclined, we are happy to, you know, talk to you online.
Yeah.
And what we do is that I know one of the big fears people have about speaking to solicitors is cost. Yeah. We don't charge you for speaking to us. We charge you for working for you.
Yeah.
So feel free to speak to us.
And I'm gonna tell my viewers and listeners that we are negotiating a discount for everybody who actually is on our platform, so that we can negotiate a good discount for you on Lexpert Solicitors discount. So Ken, thank you so much. I'm going to I'll collect your details and I'll put on the video when it's done up. And you know, I would be interested in inviting you live on, of course, will be online, to also again to do a presentation. Not in an interview setting, but also in the kind of presentation in a talk form.
It'll be my pleasure.
Brilliant. It's been nice having you on the platform.
Same here.
Thank you so much. All right. Take care.
Bye.
Bye-bye.